What are other key components of an effective estate plan? Attorney Christopher Hayner explains. Estate planning should be approached holistically. The entire estate planning field has, over the past decade or so, become a very close cousin to elder law or elder care planning. When I meet with a potential client, it's important to figure out who they are and what makes them tick. What is their personality like? Who are their loved ones, family, friends? Who and what do they care about? Pets? Charities? What are their assets? Have they done any estate planning or elder law planning in the past? Do they have a prior last will and testament? Do they have a power of attorney, health care proxy, a living will? When considering a client's assets, it's important to determine if they have other assets than bank and brokerage accounts. For example, do they have retirement accounts like IRAs and 401ks, 403bs, etc.? Do they own real estate, primary residence, rental property, vacation property, co-ops, condominium, timeshares? Are they expecting an inheritance from a family member or loved one? Are they a beneficiary of a trust set up for their benefit? In many instances, the above described assets are overlooked, but they are extremely important to consider in ensuring an effective estate plan. The holistic approach we employ encourages all clients not only to consider the above-noted assets and the client's desired disposition of these assets upon passing, but we always encourage clients to review and perhaps change the beneficiary designation on some of these assets. Estate planning should not only encompass the creation of a last will and testament. Talking about and reviewing these assets and the beneficiaries named to such assets is essential, because if a particular asset has a beneficiary designation in place, this beneficiary designation will control and override what is spelled out in a client's last will and testament, which, in many instances, can often frustrate the whole reason the client created a will in the first place. As far as family relationships and other relationships are concerned, it's extremely important to determine if any intended beneficiary is a minor or a disabled person. If so, certain planning can be extremely beneficial. If a client is married, is this a first marriage or a second marriage? If a second marriage, does the client have children from the prior marriage? If the client has children, does he or she intend to disinherit any child? Are there other special circumstances to consider? Exploring these relationships is not only helpful, it's crucial to creating an effective estate plan. Also, besides considering creating a last will and testament, a client should always be informed of the trust planning available, including the creation of Medicaid Asset Protection Trust, if long-term care planning is desired. In addition, does the client have a current and effective power of attorney, health care proxy, and living will? If so, do these documents still meet with the client's wishes and desires? Having an appropriate power of attorney and health care proxy is a must for most clients. Without these documents, a client's financial and physical well-being may be at risk, even in the face of the most carefully created last will and testament and trust. Call now for a personalized evaluation or visit his website at www.chaynerlaw.com.